the order from the judge. So this is the same case, Google versus Acoustic Solutions, spelled EQUUSTEK, plus no step on Sneck. Order granting plaintiff's motion for preliminary injunctive relief. Plaintiff Google LLC brings this action against Acoustic Solutions. Klarma Enterprises? Really? And Robert Angus, together Acoustic, to prevent enforcement of a Canadian court order requiring Google to delist search results worldwide. Google now moves for a preliminary injunction. Acoustic has not filed an opposition brief. Google's motion will be granted. In its reply brief, Google indicates that the defendant, Robert Angus, faxed a letter to Google's counsel and to the clerk of court. According to Google, this letter declared defendant's intention not to defend and argued that Google's motion is unnecessary and unfair. The letter has not been filed on the docket, and in any event, the court does not review or respond to letters or letter briefs. See Standing Order 2. Judge Davila does not review or respond to letters or letter briefs providing case information or seeking relief from the court, even if the letter is filed on the docket. As such, the court will not consider facts or arguments raised in Angus's letter. So that's important. This was basically an unopposed motion for preliminary injunction, but I think the court's still going to go into some detail. In 2011, Acoustic filed suit in Canada against a group of individual and corporate defendants associated with Datalink, a rival computer hardware distributor and seller. Acoustic alleged that Datalink had colluded with a former Acoustic engineer to incorporate Acoustic's trade secrets into Datalink's products, and that Datalink misled customers who believed they were buying Acoustic's products. In 2012, Acoustic obtained several Canadian court orders against Datalink. Datalink refused to comply and fled the country. The Canadian court issued an arrest warrant for the primary individual defendant, but he has not been apprehended. In September 2012, Acoustic asked Google to remove Datalink's websites from its search results. Google refused. However, after the Canadian court granted Acoustic's request for injunctive relief against Datalink, Google blocked more than 300 Datalink websites from appearing in its Canada-specific search results at google.ca. Google did not remove Datalink websites from search results targeted to users outside of Canada. Acoustic then sought a Canadian order requiring Google to remove Datalink websites from its global search results. On June 13, 2014, the Canadian trial court issued an order requiring Google to delist Datalink search results worldwide. The trial court later issued 9 supplemental orders directing Google to delist additional websites associated with Datalink. Google has complied with the Canadian order. Google appealed to the Canadian Court of Appeals for British Columbia, which affirmed, then to the Supreme Court of Canada, which issued an order affirming the trial court's order of June 28, 2017, or on June 28, 2017. Google filed this action on July 24, 2017, seeking a declaratory judgment that the Canadian court's order cannot be enforced in the United States and an order enjoining that enforcement. Google now moves for preliminary injunction relief. The legal standard for a preliminary injunction, the party must establish that it is likely to succeed on the merits, that it is likely to suffer irreparable harm in the absence of the relief, the preliminary relief. The balance of equities weighs in its favor. We'll get to what that means. The judge is going to go over that. And that the injunction is in the public interest. Courts in the Ninth Circuit apply a sliding scale approach in which the elements of the preliminary injunction test are balanced so that a stronger showing of one element may offset a weaker showing of another. Google argues that the Canadian order is unenforceable in the U.S. because it directly conflicts with the First Amendment, disregards the Communication Decency Act's immunity for interactive service providers, and violates principles of international comity. Likelihood of success on the merits. Section 230 of the Communications Decency Act immunizes providers of interactive computer services against liability arising from content created by third parties. It states that no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. Congress enacted Section 230 in 1996 to address the threat that tort-based lawsuits pose to freedom of speech in the new and burgeoning internet medium. Tort-based lawsuits are civil wrong lawsuits like defamation and there's a whole slew of them. They're mostly civil wrongs. Like if you hit somebody with your car, you didn't intentionally hurt them, but you are civilly liable to them, and that's considered a tort under the law. Section 230 does not allow internet users to escape accountability for publishing unlawful material. Rather, it reflects Congress's policy choice not to deter harmful online speech through the separate route of imposing liability on companies that serve as intermediaries for other parties, potentially injurious messages. To qualify for Section 230 immunity, Google must show that 1, it is a provider or user of an interactive computer service, that the information in question was provided by another information content provider, and 3, the Canadian order would hold it liable as the publisher or speaker of that information. Here, Google satisfies all 3 elements. First, there is no question that Google is a provider of an interactive computer service. The term interactive computer service means any information service system or access software provider that provides or enables computer access by multiple users to a computer server. Google is an interactive computer service, an entity that provides access by multiple users to a computer server. There is no doubt that Google qualifies as an interactive computer service. These are citing cases that Google has been involved in. And another case finding that Google is a provider of an interactive computer service. Second, DataLink, not Google, provides the information at issue. Google crawls third-party websites and adds them to its index. When a user queries Google's search engine, Google responds with links to relevant websites and short snippets of their contents. Google's search engine helps users discover and access content on third-party websites, but it does not provide that content within the meaning of Section 230. See the O'Crowley case, holding that Google cannot be liable for merely providing access to and reproducing allegedly defamatory text in the form of links and snippets in search engine results. Third, the Canadian order would hold Google liable as the publisher or speaker of the information on DataLink's websites. The Supreme Court of Canada ordered Google to de-index the DataLink websites from its global search results because, in the court's view, Google is the determinative player in allowing the harm to occur to Acoustic. The Ninth Circuit has held that, regardless of the underlying cause of action, a claim treats an intermediary as a publisher when it requires the intermediary to remove third-party content. And this is the Barnes v. Yahoo Inc. case. The Barnes panel held that removing content is something publishers do, and to impose liability on the basis of such conduct necessarily involves treating the liable party as a publisher of the content it failed to remove. The Canadian order treats Google as a publisher because the order would impose liability for failing to remove third-party content from its search results. So that's a little bit cryptic paragraph there. What they're saying is that the order applies to Google, and that would normally, we stop there, right? No. What happens if Google doesn't comply? Well, then Google is somehow in violation of the court order. It's somehow liable for its behavior now. It's in contempt of court or something, and it can be hauled into court for the violation. So now Google is liable. Google is damaged. Google can be injured if it does not comply. So because that level of order / compliance / remedies for non-compliance reaches that level, that means that the Canadian order treats Google as a publisher of the information and not as an intermediary. And so that means it does meet the requirements for Section 230 immunity. The court finds Google is likely to prevail on the merits of the Section 230 argument. Google is harmed because the Canadian order restricts activity that Section 230 protects. In addition, the balance of equities favors Google because the injunction would deprive it of the benefits of U.S. federal law. It is clear that it would not be equitable or in the public's interest to allow the state to violate the requirements of federal law, especially when there are no adequate remedies available. An injunction would also serve the public interest. Congress recognized that free speech on the internet would be severely restricted if websites were to face tort liability for hosting user-generated content. It responded by enacting Section 230, which grants broad immunity for online intermediaries. The Ninth Circuit said Congress wanted to encourage the unfettered and unregulated development of free speech on the internet. The internet and other interactive computer services offer a forum for true diversity of political discourse, unique opportunities for cultural development, and myriad avenues for intellectual activity. It is the policy of the United States to promote the continued development of the internet and other interactive computer services and other interactive media, and to preserve the vibrant and competitive free market that presently exists for the internet and other interactive computer services unfettered by federal or state regulation. The Canadian order would eliminate Section 230 immunity for service providers that link to third-party websites. By forcing intermediaries to remove links to third-party material, the Canadian order undermines the policy goals of Section 230 and threatens free speech on the global internet. Google's motion for preliminary injunctive relief is granted. It is so ordered November 2nd, Edward Davila, United States District Judge for the Northern District of California, San Jose Division. So, up yours, Canada. That's what you get for trying to take our free speech. Yeah, you take that, Canada. You can't take our free speech, even by court order. You got it? So what do you think about that? That's a very interesting case. Yeah, so this is also a great example of international law. You see how Google had to go all the way through Canadian court and comply with Canadian law in Canada, and then they had to come when the thing came to the U.S. and there was an order against something in the U.S., then they went into U.S. court and applied U.S.ian law, and that law played out differently. It played out according to the U.S. law. It played out according to the Communications Decency Act and the principles of the First Amendment, as we would kind of expect. So Google doesn't have to delist data links websites from their search results in the U.S. Not that anyone really cares. This is more about the principle of Canadian courts or outside courts, international courts, being able to order something to be done in the U.S. because of something in the U.S. that is affecting them internationally. So that's a very interesting way that plays out, because you could definitely make the argument that the Canadians, that Acoustic is being injured by whatever's on the data link website, and that there's no practical reason why Google shouldn't delist the data link search results, other than that's not how Google's search indexes work, and that's also contrary to our principles of free speech. Certainly remove data links websites from the web, like order them to remove them or something like that, but it's not Google's job to tell us what is and isn't on the web by court order. It's Google's job to tell us what is and isn't on the web by actual practical indexing. I wouldn't want to think about a world where I have to wonder what search results have been censored out of my search results. So if I search for a controversial news story because I'm an attorney who's been hired in the case and I'm doing my research, am I going to be limited because censorship has meant that I can't research certain things. I'm thinking of the Great Firewall of China, is what I'm thinking of when I'm speaking here.